I think we're ready to call to order the 39th, excuse me, the 39th meeting of the Mass Gaming Commission on Tuesday, December 11th, bright and early in the morning. Thank you, everybody, for coming. What we're here today to do is to begin a conversation about a host of what we refer to as key policy questions, some much more key than others as we've gone over them. But basically issues that we need to resolve soon in order that we can get the regulations written properly, but in a way, more importantly, so that the applicants and municipalities know what the rules of the road are going to be on a variety of different issues where we have an interpretive or an additive role to the legislation. And we've sequenced these in priorities 1, 2, and 3. We probably will not get to the 3s. A lot of the 3s were issues that really aren't critical path questions. We realized as we went over them. But before the week is out, we definitely will get through all of the top priority and the mid-priority questions. The questions have all been assigned out to a commissioner to take the lead on reviewing and making a recommendation. The recommendation is obviously just a recommendation. It's for us to consider. But everybody we had to start somewhere, so every commissioner has taken a chunk of them. Any other introductory thoughts or anything anybody wants to say? Anything you want to say about Louisiana or anything?
Nothing I want to say.
Right.
No, it was. I spent Chairman's references. I spent some time in Louisiana last week on personal matters, but spent 2 days with the Louisiana Gaming Commission, and then both in Baton Rouge and then in New Orleans, and learned a great deal that will be detailed in a report I'll circulate to the Commission later, both about the way they approach the regulatory process, some of the problems they've run into, and then how they deal with a large urban casino. The casino in New Orleans is 100,000 square feet of gaming space, and is right in the center of town, and has been built over a number of years. Started out much smaller, built, and is the product of extensive negotiations between the city of New Orleans and the casino operators. And that whole process was interesting as well. And some of the considerations that they took into account in dealing with those negotiations to ensure that the casino operated in a synergistic fashion with the surrounding community. So I'll detail all of that in a memorandum that I'll circulate later. Not all of it's entirely applicable to us. Every place has its own unique characteristics. But they made great efforts to ensure that the casino built on and synergized, if that's a verb, with the surrounding community, to the point of, initially at least, not allowing a hotel until they were convinced that the existing hotel capacity couldn't support the demand that the casino was producing. As I say, that's not necessarily something that we need to take into account, but it's the kind of approach and the kind of how is the casino going to fit in with the environment that permeated the thinking that they explored. So it was a very valuable 2 days.
Was it only the business environment, or was the cultural design environment too?
The cultural design, it's a little hard for me to get a handle on the cultural design. It's kind of freewheeling down there. But it was primarily, from the part at least that I understood, the business environment. Right. Restaurants, hotels, performance venues, and the like. And they were very careful to ensure that this would not have a deleterious effect on those, and in fact would enhance them. And therefore allowed progressively, as I understand it, a progression of restaurants in the casino, progression of satellite properties that the casino could build, and the like, to make sure that it worked. So
Great.
it was interesting. And then their whole regulatory structure is very different from the regulatory structure we have. And they have something down there called, which I know our consultants are thoroughly familiar with, video poker, which is well, you haven't seen anything quite like that. It's video poker machines in restaurants is the second category, and truck stops. And the truck stops, as one commissioner explained to me, before video poker, there were 8 truck stops in Louisiana. And with the advent of video poker, the number rose to 282. To the point, coincidentally, there was a lot more truck traffic, I guess. But that too is an interesting phenomenon. It is basic electronic gaming in these various facilities, and the way they approach that in terms of how they control those basically slot machines, as opposed to the way they control the slot machines in the casinos, and they have a different way of doing that, is illustrative and interesting as well. So it was a very helpful 2 days.
Great. Well, we'll look forward to hearing more about it. Okay, so as for process, I think we should just run through these in sequence. We did get quite a few comments from various interested parties, which we'll try to allude to. They were very much part of our consideration. We do have our consultant team here, 4 members of our consultant team. We also have Anderson and Krieger is tracking this online. They're available for questions. If we need one, they're available by phone at a moment's notice. I think the way to proceed is just, excuse me, for the relevant commissioner to go ahead and talk through this, and then pick up the discussion after the recommendation from the commissioner. So we'll start out with key policy question number 16. Excuse me. Should the commission confirm through a formal policy that no host community agreement should be executed or referendums held before the relevant applicant is qualified through RFA 1? This, as everybody remembers, was one of the major issues we discussed in the situation with Springfield. Springfield initially had come up with a schedule that would have had them selecting one or more, or initially it was one finalist in their community well before our background checks, RFA 1, was done. We felt that there were some issues with that. We talked about it with Springfield, and we agreed that they would change their schedule, and they will not now finally execute their host community agreement or agreements or have a referendum until after we have completed our background check and until whichever applicants they're dealing with have qualified. But even though we had discussed this quite a bit, there was some concern. Ombudsman Ziemba in particular noted that there was people that wanted to comment on this, so we decided to wait. We received 11 different submissions on this. Sterling Suffolk said that they were concerned about the delay of a execution. Once a execution of a host community agreement is completed, there needs to be a minimum of 60 days before the referendum, which creates a time issue. Suffolk was also very supportive of the general issue of local control. The town of Lakeville weighed in basically in the same way, saying that they did not think we should have to approve the bidder prior to the HCA or the referendum. City of Boston largely made the same point, again emphasizing their belief in the principles of local control versus the use of the Gaming Commission's authority. 3 individuals, Paul Vignoli, Philip Cataldo, and Martha Robinson, all wrote in and were in favor in both cases, on all 3 cases, that we should wait for suitability. They said it was that the communities need to know the legal and financial histories of the proposers before the community agreements and the referenda are written. Springfield was basically silent, said that this is a decision which is best left, sorry, this was MGM Springfield, the bidder. One of the bidders in Springfield said this was a decision best left up to the commission and the municipalities. Shevsky and Freilich, the consultant to the city of Springfield, said yes, we should standardize the rules. Other regions should have to comply with the same rules that we agreed to with Springfield. Metropolitan Planning Council agreed, saying that we should, however, we should not permit the execution of an HCA or a referendum prior to the suitability checks, but that we should encourage the communities to go ahead and start negotiating, just don't get to the end of the game. And finally, the city of Revere weighed in on the same side with the city of Boston, emphasizing the principles of local control and asking that we not require a suitability test before these two things. I got a bunch of letters yesterday that I didn't have they came in at the very end of the day and I didn't have a chance to distribute them. They relate to this issue, but also a number of the other issues having to do with the content of the host community agreement, the content of the referendum summary of the host community agreement that would be voted on, the definitions of supporting communities, surrounding communities, a number of the questions that will be on our agenda tomorrow. But since they relate to this one, I just want to highlight some of them. It's basically from the construction trades of one sort or another. The IBEW wrote in and said Local 103 would also like to voice its support of Mayor Thomas Menino and his stance on the local process required by the Gaming Act. The commission should allow municipalities to exercise the authority given to them in the Gaming Act without delay or interference. Local Council, District Council 35 of the Painters and Allied Trades urged the commission to begin the casino application and development process immediately. The Greater Boston Labor Council, the AFL-CIO, said, I'd like to express the council's support for Mayors Menino and Rizzo. That's the mayor of Revere who wrote in. The local process should be left entirely up to the discretion of the local governments as intended by the Gaming Act. This letter also gave some context, basically that from the construction trades and some of the other labor organizations, the argument is we need the jobs, basically. And this legislation was passed in substantial part because it's supposed to be a job generator and an economic development tool, and we want you all to get moving as fast as you possibly can and to not delay for any Mickey Mouse process. There is also a lot of misinformation floating around. For example, this talks about New Hampshire could be laying the groundwork for facilities to open within a year. I don't think there's any possibility in the world that that could happen. But nevertheless, you get the point, and it's a legitimate concern. We've heard from Frank Callahan from the construction trades a number of times, and that correspondence all came to add to that sense. So after I thought about all this, and I talked at length with Ombudsman Ziemba, I came to the conclusion that notwithstanding the concerns expressed, that it is very important that well, first of all, that the principle that we established with Springfield was a very important one, and it's absolutely critical, if we think it's an important one, that it be standardized across all regions. It would make no sense to have one standard in one community and one not. The issue that we have talked about a lot is that particularly if there were a referendum on a proposal, on a host community agreement, on a particular proposal, and that proposal ends up not being approved by us, that proposer ends up not being approved by us, it is a colossal waste of time and money by the community, by the developer, although that's their problem if they want to participate, but particularly I think for opponents who are likely to have fewer resources. to try to get geared up to fight a fight that they then have to fight all over again because that company did not get approved. So I think the HCA is a little bit, when the word that we used in the question was execute the host community agreement. I wrote that what I meant by execute was absolutely finalize. And I think the most critical issue is the referendum. I mean, the host community agreement can be reopened and negotiated probably pretty much at any time. But as a practical matter, since the host community agreement will be what the referendum is on, the two kind of fit inherently together. The one issue that I was troubled by, and I hadn't really thought about before the commentary came in from Suffolk, is this issue about the window of time between the final execution signing of the host community agreement and the referendum. And there has to be no less than 60 days, no more than 90 days between it's actually between the request for a referendum, which effectively is the signing of the HCA, and the referendum. So if we finish the suitability check background test in June, you can't have the referendum at the earliest until 60 days thereafter. And that's a legitimate concern, given everybody's concern about moving quickly. But you can't expect people to join the issue in advance of knowing whether or not a party is going to be approved or not. There has to be time to have the debate. So I think we're stuck with this 60-day. There may be some way to create some kind of wiggle room there, I'm not sure. And that's worth talking about. Is there any way we could are we concerned about that 60-day time frame? And if we are, is there some way to wiggle room around so that we might shorten it? I'm not sure that I think we should, but I would be open to thinking about it. But when all is said and done, I think we came to the right conclusion with Springfield. It's absolutely critically important that the communities not make final agreements with people who have not passed the background checks. I mean, there's nothing more fundamental in our licensing and regulatory process than to make sure that the people who are in the game are people that we want in the game and who pass the most rigorous standards. My conclusion is that, my recommendation is that we should stick with this proposal, stick with this standard. I think it's entirely appropriate to encourage the communities and the vendors to be negotiating, and we're supportive of that, we're helpful with that. It can be right on the cusp of final completion or final execution, but I don't think it should be finally signed, and you certainly should not have a referendum until the applicant in question has passed the suitability test. So that's where I come down on this one. Anybody else?
Yep, I, for all the reasons that you state, Mr. Chairman, I would agree with that. Answering this question in the affirmative, I believe that the principle of local control is well preserved throughout the process, and it's really a question about timing, but an important one that has, as you state, important repercussions for everybody if somebody was to fail a suitability test. I believe people could get creative with the timing and the wiggle room that you mentioned, to the extent that we can issue decisions on passing the suitability test on a rolling basis, let's say. I mean, we're giving ourselves a 6-month period in our time frame, but we all have talked a little bit about how some of those decisions, depending on who's being analyzed and the complexity of those organizations, could be on a rolling basis. So I don't want to concede yet necessarily that everybody has to wait until the end of that and then begin a 60-day period. Right. There are ways, in my mind at least, possibly, that some of that could be gained in terms of preliminary decisions or rolling decisions. So
Yeah, I don't think there's any question that we're not planning on holding everybody back until everybody's approved.
Right.
Other thoughts or?
I had a couple of thoughts. Number one, I would just like to comment on the let's go now and stop the delay theme of the letters and other things that we're hearing. And I think every one of us is committed to proceeding as quickly as we possibly can. And I know we've emphasized that in a number of contexts before. At the same time, these two recent trips that I took, or visits that I had in connection with personal trips, in both Mississippi and in Louisiana, emphasize for me, if any additional emphasis was needed, the importance of this qualification process that we're embarked on right now. It is critically important. And the opportunities for mischief, to use the most benign word, that exist and that have been documented in other jurisdictions are really far too numerous for the public safety and the public integrity of this process on which we're embarked to be sacrificed by a rush to the end we all desire to achieve. And if further emphasis on that score is needed, one only needs to read the report of the Pennsylvania grand jury that took a look at the way Pennsylvania went about it. So I am committed, as I know all of us are, Mr. Chairman, to moving as quickly as we responsibly can. But the word responsibly is a huge component of the task that we've been given. And that the public and the people who appointed us and the legislature, I am convinced, want us to follow. So I understand the emphasis, I understand the need, I understand the desire, but I also understand the need for responsible progress. I think that insofar as the specific topic, that insofar as the vote is concerned, I am in full agreement. I think that it would not be a good use of the public's energies, considering all of the opponents and the proponents, to have an election before the qualification process were done. The qualification process may not absolutely rule out an applicant, but there may be things that turn up in the qualification process with respect to particular qualifiers that the public would like to know before they had the vote. And so I think it's really important for the integrity of the process for the vote not to take place until after that is done. And that is what Springfield has certainly agreed to do. I'd like to hear more, though, about the execution piece. The execution piece is the product of a negotiation between the town, city leaders and the applicant. I assume that it can be revised at any time, and maybe that's the point to which you were referring. The required vote under the statute comes not 60 or 90, not less than 60 or more than 90 days after the execution, but after the request for an election, and the request has to come after the execution. So there is a way to deal with the timing there by when you make the request. And there's nothing in the statute that says you can't have serial requests if the time expires. So, I mean, there are ways, as you say, to do it. But I wonder why we would want to put restraints on when the agreement could be executed, so long as it was clear that the agreement, could be revised at any time before the request for a vote was made. In other words, once the request for a vote is made, the agreement ought to be locked down so that the process of informing the public as to its content can begin. But until that time, it seems to me that the request can be, that the agreement can be somewhat fluid and doesn't have to be locked down to that degree.
That's-
And I'm thinking of the 60 to 90 days that would have to start after the end of our investigation. And if our investigation took us until the end of June, you're talking about at least September before you can have the vote.
Right.
Well, to that point of execution, I guess it's all conceivable that, and that's the way I always was approaching this question, that communities and applicants will conduct negotiations and may have full agreement in principle without the execution, which they could be done for all intents and purposes before that so-called signing, if you will, or ultimate execution. I think nobody is suggesting that all of those negotiations should wait, and I guess they haven't, and that's good.
Why then do we put an emphasis on execution as opposed to some other term that says you have to, that you can't take a vote?
Well, there's one.
Why do we place the term, the emphasis on execution?
Yeah. Well, first of all, the emphasis is not on execution. The emphasis is on the referendum, and I think this is what you're talking about is a fair point. But there is, it is a little weird to have a community execute, sign, finalize, done, announce, show to the public, put in the paper, the final execution of an agreement with a company that a month later we might say is not going to be an applicant. So it's not likely. But it's possible, and it happens all the time across the country. So I think the community would feel a little silly, and everybody would just sort of, I don't guess it doesn't really matter as a substantive matter to us as long as the referendum doesn't start. But there could also, that's one issue. The second issue would be there is a possibility that there could be something in a host community agreement that we might end up precluding. I'm just totally making this up, but say we do the investigation, we find it in some community, that some other jurisdiction, there was some kind of an inappropriate relationship with a hotel supplier or something, and we feel that we have to go into their proposal and say, look, you can't do business with that hotel company, and that hotel company is in the host community agreement. So there are some things that could happen, the most significant one being our denial of suitability that would make the execution of the HCA have been, silly.
I'm sorry.
First of all, I agree with your assessment of the issues. Secondly, I think the issue here is timing. Is this going to hold up the process? I think that's where all these comments stem from. And this 60-day period would be running at the same time as our phase 2, correct? I mean, it wouldn't hold up the phase 2 process that we'd be undertaking.
No, our phase 2 wouldn't start until after the referendum. So, I mean, it is
A timing issue.
there is a 60 to 90-day window, which will be time that will be extended if this did not occur.
Okay.
I mean, I could certainly drop the HCA issue. I don't feel, if a community wants to execute a host community agreement with somebody that they don't know whether or not we're going to approve, you could take the position, and I guess it's what, Boston and Revere are saying, if we want to do that, it's our business. And it doesn't really, it might cause them some embarrassment, but it doesn't do anything to us. The issue from our standpoint is the referendum. So, we could make that the point here, drop the HCA, let the community do what it wants to do on the HCA. Do you see any reasons, consultants, why that would be a problem?
No, Mr. Chair, there's one, Mike Pollock.
Mike Pollock from Spectrum Consulting, yeah.
Good morning. One additional point from, I guess, from our experience here is that.
Mike, can you use the,
Sorry,
come on up.
certainly. Good morning.
Good morning.
One additional issue from our experience, and I guess this ties into your comment, that the critical issue is the referendum as opposed to the host community agreement. And one of the issues that we wanted to bring to your attention is that by putting the suitability investigation first, as opposed to having it after the process, would in effect relieve pressure on the commission, which would be significant. And we have seen this in other states, that if there is a host community agreement in place, and more importantly, a referendum that's already been approved, and you're conducting the suitability investigation or rendering a decision on suitability after that point, it will raise issues or put pressure on the commission, essentially.
To both move quickly and to approve, because,
Yes, I mean, the public pressure to approve in those instances is very real. And you would not necessarily be making the same decision in the same context as you would absent that pressure. And that was just wanted to bring that up to your attention.
well, that's a
I would agree.
fair point.
That's a
yeah.
fair point.
Yeah.
Not only that, we could be facing two applicants with very distinct timing. If there was a community that has passed a referendum and one that, for whatever reasons, are still conducting a negotiation, let's say, while we're doing both investigations.
Well,
So there could be.
yeah, and there's another factor, obviously, that, you know, take Western Mass, which is the easiest case, there looks like there will clearly be more than one proposal, so we can't get moving until, well, I guess, until the last one comes in, but that doesn't keep the individual applicant from moving forward with their own phase two, so there's some cost there. I'm going to ask, this is an important enough issue that I'm going to invite if any of the representatives of the applicants want to say something on this. I mean, I'm going to have to cut it off if it becomes just speechifying, but if you've got anything substantive to add to what we're wrestling with, you know, please do.
Thank you, Mr. Chairman. John Stefanini. I represent Sterling Race Course LLC, operating as Suffolk Downs in East Boston and Revere. And I appreciate Commissioners and Mr. Chairman the opportunity to testify. I won't go over the testimony we have. It's on pages 6 to 9 in our testimony. I'd make a couple of observations that are not opinion-based, but we tried to keep our focus on the statutory construction, the legislative history, and how it relates to other statutes and independent authority that exists. And there is a concept, there are several concepts and principles that I think are being confused. The first is New England and Massachusetts has a strong tradition of local and self-governance, which permeates through all of our state statutes and permeates through this statute in particular. That's in stark contrast to the consultants and behavior of gaming commissions in other places. So, for example, in Pennsylvania, the Gaming Commission can decide where to place it in a community without the community say so. The community can fight it on zoning and regulatory pieces. In Massachusetts, because of our local self-governance, there was a belief by the legislature, and the statute, I believe, is very clear on this point, that the condition preceding to you seeing an application is that the person would have to go through a local process. Not subsequent, not sequential, not simultaneous, but in fact, it's before. And if you read the statute, it says, before filing an application, the applicant shall submit to the commission. So the first piece is, I think that there is a sense that that the commission needs to do that. In fact, the statute was very intentional in saying, we want our local representatives to have the first voice in this, so that in fact, a commission cannot, by its insistence, force a community to consider something that it doesn't otherwise want to consider. Second point is, there is some confusion, and I see in your advisories, which have been different on this. Your early advisory was to proceed, and then post-Springfield it was to not proceed. the host community agreement and the referenda are two separate concepts in the bill, and they're not related. The referendum is not a referendum on the host community agreement. It is, in fact, if you look at chapters 53, 54, and the election laws in the Commonwealth and similar statutes, it's a very specific question, and it's a specific, unique land use question that's being asked, yes or no, for the community. They're not asking the question, do you approve this applicant? They're not asking, do you approve this proposal? They're not asking if you agree with this host community agreement. They are asking, do you allow for the use of gaming on this specific site? It's a very specific question. And there are,
What's the relevance of the summary in that case?
the summary prepared by the local council, as determined in section 15, is for them to summarize what it means. And so they would have to say, the community voting in favor of this would in fact be voting to allow gaming as a use on this site, in this community. A vote against it would be to not allow.
Which would describe essentially what's in the host community agreement.
It would not. That's not the question.
No, the question isn't that way, but that the ballot question, the statute says, shall be accompanied by a concise summary as determined by the city solicitor of the
Correct.
host community agreement. Yes, but you can't simply, it seems to me, in a matter of statutory construction, disassemble the question from the surroundings with which the question has to be presented to the public. This whole process of having the summary available for a certain number of days, having the ballot question accompanied by the summary, means that the question is designed by the legislature to be considered in the context of the summary, which is a summary of the proposal. So I hear what you're saying. The precise question is a land use question, but it's accompanied by a summary of what the city and the developer have negotiated.
So, Judge, what I would say to that is, if you look at the legislative history, there were all kinds of proposals in the legislative process to have the referendum mean more things. And in fact, the legislature, in drafting that section, you recited it almost word for word, and then you added at the end of that, and host community agreement. The section that you're referring to does not say a summary of the host community agreement. It says prepared with a summary, and it's referring to the question. And so if you look at chapters 53 and 54.
Right. Can we just stop there, because I'm confused now. What the language is, provided further that at such election, the question submitted to the voters shall be worded as follows, quote, shall city or town of X permit the operation of a gaming establishment licensed by the Massachusetts Gaming Commission to be located at description of site, yes or no? Provided further that the ballot question shall be accompanied by a concise summary as determined by the city solicitor or town council. Now, are you saying that the summary is a summary of the
question?
15-word question?
That's correct. That's the way ballot questions have worked.
Well, I hear you.
I think I would make an observation, having had the opportunity to serve in government and to work for governmental bodies on both sides. I think you make very clear policy arguments for what you're talking about. And Mr. Chairman, I think I would say you make very clear policy arguments as to why you should look at things. What I would suggest to you is that the legislature, in deciding its policy considerations, considered many of these things, and they made a decision that they didn't want to follow the jurisdictions of other states and to have local control up front. So there may be a reason why the commission should have control up front. The legislature decided it didn't want to do that. There may be a reason why you want the host community agreement, the suitability of the developer as part of the referenda, but in the legislative history and in the statute's clear language, that's not what the legislation says. It says that the local community has the ability to decide in its sole discretion a host community, because they're the people best positioned to determine the impacts. Now, the commission has complete authority to deny or not issue a license. The commission clearly has the ability to evaluate impacts on a local community, be it design, be it business impacts, be it entertainment venues, be it jobs, be it
We know all
gaming.
this, we know all this part, and we're talking.
But your role in that process,
Understand,
the
right.
way it's defined, is to take all of the policy considerations that you have and deal with them in the context of your decision-making, your deliberation, not in terms of upfront dictating the timing, the content of what the referendum should or shouldn't mean. That was not envisioned. In fact, there were amendments in the Senate to make the referendum a land use vote as part of the right use, and it was adopted in the Senate and rejected by the conference committee, in part because they did not want the other independent processes to invade that process.
Mr. Stefanini, I'm just looking at a section further, a little bit before the one that you talk about on the actual vote. And where it reads that 90 days after the request for the referendum has been received and the sign and host community agreement are going to be made public with a concise summary approved by the city solicitor or town council and has to be posted on a website. So that concise summary,
Within
I
7
believe,
days.
right. That concise summary is what Commissioner McHugh is saying has to be summarizing the host community agreement, which is also going to be subject of the election later on, which leads me to believe and conclude that the summary is not on the question, but on the host community agreement.
So what I would say to
just
that,
point
Commissioner, is you're looking at two different sections in terms of statutory construction.
No,
So you have
it's the
to,
same section, it's just a little bit
Subsection.
further, yeah. Well, it's the same subsection. At the beginning of section 13, which is the one that articulates the vote, but.
oh, you're reading the top of this, okay, I'm sorry.
Yes.
It says,
This concise summary is also approved by the city solicitor. So that those two pieces lead me to conclude that the concise summary at the time of the vote has to be on both the question as posted and the summary of the host community agreement.
but the concise summary in that instance, they're using the same terms, but the concise summary there is of the host community agreement, which will be posted no later than 7 days after the agreement was signed.
Right.
So it's a condition precedent to proceeding with the question, but it doesn't change the specific ballot question, nor does it change the concise agreement within the context of the question is the
See,
question itself.
let me interrupt, because we're going to talk about the summary and the host community agreement, and I think I have more concern about whether we should approve the language of the summary now than I did before. I'm concerned about the way you are parsing this, that I'm not sure is consistent with what would really serve the public interest here. But in any event, and what was intended, just to be clear on that point. But that's not the topic on the table. I mean, the earlier part of your point was, should we exercise, the question was, should we exercise the authority to, or do we have, and should we exercise the authority to preclude a referendum prior to the approval in RFA 1, the suitability in RFA 1? And you, I think, make a legitimate and important point that about the legislative intent of local control and the power of that. And we have made, to be candid, we have said in other environments that our job is not to protect the communities from making bad decisions. They might make bad decisions, but it's their business. The question is whether or not giving them the ability to make what we would deem to be a bad decision ultimately hurts the overall process, where we do have the authority to assert ourselves. And I don't think it's a trivial point. I think your defense of the local control intent is really interesting and legit. But I also think that the offsetting consideration is if a community goes off and executes an agreement and has a referendum, and we then say that the the applicant is not suitable, that feels to me like it was utterly unnecessary to go forward, and there was no need to go forward. And the cost to the whole process is huge. It slows everything down enormously. The public is going to say, what the hell is going on here? That seems to be a macro issue where asserting our net constructive authority over the perfectness of the local control is the greater consideration.
There's something else that I could add, and I'd welcome your comment on this too. I could add to that. And there is no question that this statute is designed and written to give a great deal of authority to the host community. And from the outset, I thought, in a basically hands-off mode, at least at the beginning. But that's not all there is. It seems to me that the statutory framework, if one steps back and just looks at the scheme, has three components in terms of the commission's role vis-a-vis communities and others. The host community really has an opportunity to deal with the developer in the way that the host community deems best. And the commission has a restrained role as a consequence. Insofar as surrounding communities are concerned, however, the commission has a greater role because they don't have a seat at the table. And the statute makes it clear that unless they can on their own negotiate a satisfactory agreement with the developer, the commission has a role in facilitating creation of that agreement. So the commission has an increasingly greater role in the relationship between the developer and the surrounding community than it does with the host community. And then there's the region, which doesn't get any seat at the table and doesn't have any opportunity, statutory opportunity, to deal with the developer, putting to one side now affected businesses,
Entertainment.
municipal venues, performance, putting to one side, doesn't have any opportunity, but the interests of the region permeate the statutory scheme and the considerations that the commission has to have in mind. And in that regard, the commission has, it seems to me, and must assume, a more greatly protective role. Now, how does that all interact here? It seems to me that a hands-off role with respect to the content of the host community agreement is a starting point, at least, for the commission's approach to the host community agreement process. The timing, though, affects the region as well as the surrounding communities, because there is going to be a great deal of energy focused, both pro and con, on whatever proposal emerges. And it seems to me that the commission has to assure that the surrounding communities and the people in the region who are interested in this have an opportunity to see both concretely what the host community agreement consists of, and an opportunity to marshal the forces, pro and con, and work on their like-minded associates in the host community so that the vote truly represents a full and informed plebiscite. That's kind of a windy dissertation as to how I look at this, but it does seem to me that there is, therefore, a role for the commission from carrying out those responsibilities, both in, certainly in the timing of the election. And I've already expressed earlier my haven't come to a conclusion as to about the execution, but certainly as to the timing of the election.
So, Judge, I would agree completely with your structure. I think you well articulated that. I would say that if you look further at the statutory scheme, you note that the surrounding community authority and the regional authority to the commission is greater in each instance. So in a surrounding community, you've got to figure out the factors, you've got to act as a quasi-judicial body to determine whether or not someone is. The applicants then have 30 days to cure it, and then if not, you have the ability to step in. On a regional basis, there are a series of studies and criteria that are required, which are part of your evaluative criteria. But in the instance of the host community, none of that statutory language exists. None of the kind of discretions. In fact, if you look at the $400,000 and the amount it's given to the $50,000 is given to the host community for them to determine the impacts, for them to determine the content. And I would say to you that content and timing are different, but they all relate to the authority of a municipality, the independent authority of it to be able to do that. Mr. Chairman, I'd just like to make two comments, and then I will conclude unless you have additional questions. The first is, Pennsylvania. The Grand Jury Commission and their 21 recommendations were front and center as part of the legislative process and were incorporated in each and every instance relative to the process. And Commissioner, you, early in this process, adopted the administrative regulations for procurement, et cetera, which was the one that the legislature did not do. So I would say, in terms of that process, with the exception of the commissioners and the circumstances that were unique to that place, the legislation and the statute and the commission have adopted every single one of the recommendations to avoid any circumstances that exist like that. And it was not because of timing. It's because of the nature of their political system. And in part because of that, the legislature wanted to ensure that the authority for vesting and making the decisions of siting was split up and not driven by one entity, but by multiple entities. And to the extent you invade timing or content of a municipality, you start to regulate the entire process, when in fact, the division of the process is in part of the statutory scheme. The last point I would make is Springfield. Springfield, you in Springfield, and I watched those conversations, came to an agreement and a deal, if you will, that worked for them in their circumstances. As a practical matter, you're looking at fewer than a dozen communities that are host communities and fewer than a dozen applicants. This is not 351 cities and towns. There is opportunity on a case-by-case basis to figure out how municipalities want. And I was intrigued to read not only your comments, the comments submitted, but others. And some municipalities want the assistance of the commission because they feel like they need that level of technical assistance, that level of comfort. And some communities are so sophisticated in terms of how they deal with things, they're going to think of things and consider things that the commission couldn't begin to address because you have other matters before you. And a one-size-fits-all seems to me to be a way to avoid the creativity and independence that was designed to set up the statute the way you just articulated it. Thank you for your time, Mr. Chairman. If there are any other questions, I'm glad to answer them.
I think that's great. Thank you.
Thank you.
Thank you, Mr.
Thank you for your time.
To be fair, if anybody has anything to add, you would be welcome. If not, let's go ahead. Okay, so really interesting, important, complicated stuff. Anybody have other? First, any of our consultants want to say anything? If it's really to the point, I mean, it's.
Just briefly, with respect to the timing issue, I think that the discussions, if the legislature had contemplated that the commission consider as part of one proceeding suitability and the entire license application, then there might be some merit to the argument that as far as the control of the host agreement. However, just the opposite has occurred. In Section 12C, the legislature made it quite clear that suitability is to come first. And only if an applicant is determined to be suitable will the application then go forward in its entirety. And I think the legislative intent is that that is part and parcel of when the host agreement and the referendum would be considered.
Okay, that's an interesting point. Okay, any other thoughts? Well, let's,
I would just add that insofar as timing is concerned, Section 434 gives us the power to establish the parameters for elections under Clause 13 of Section 15. That's what we're talking. And certainly timing is a parameter, and whatever else the parameters may be. And I think we have to respect the context, but certainly timing is a parameter. And so I think in terms of power, we can do.
yeah, that's a good reference, thank you. Let me ask this question. I think we all think that if we were in a host community, we would not even want to have a referendum until we knew for sure that our partner was going to be qualified. That's our judgment. But if a community makes a different decision, does that rise to the level of impeding our work? That's the standard that we've used, I think, at least in language, that it's the local control element stops when it impedes, this is not a legal thing, this is a policy matter, when it impedes our critical process. And what I said to Mr. Stefanini is that this would be, to have a referendum precede somebody being disqualified would be so disruptive to the community, to the region, to our process, that it's appropriate for us, under the authority in that section you mentioned, Commissioner McHugh, to intercede. I mean, to me, that is, from a policy standpoint, that is the essence of the question.
You gonna-
Go ahead.
Well, I would make an argument that if any applicant, when any applicant receives a thumbs up from the Bureau of that they have passed financial and background investigation, that makes a stronger case, if you will, for a referendum because they have been deemed suitable. So I think it's also a benefit to communities saying they.
That's an interesting point. You could oppose the vote because how can we vote for this? We don't even know if they're gonna be
If
approved.
they're gonna be,
suitable.
right,
That's
as
interesting.
opposed to
Have
then,
you thought
you
about
know,
that?
here's a
Yeah.
great rationale. These people have already been
So we're
vetted by
actually,
the very
we're actually
strict-
on Mr. Stefanini's team here. Well, that's a very interesting point, but it raises, I mean, again, but the question really is, you know, if the community wanted to have there be a referendum, giving the opponents the ability to say, wait a minute, folks, you're voting on something that's, the Gaming Commission hasn't even considered to be financially and ethically suitable, you might think that's a bad idea, but does it get in the way? Does it rise to the level that we should prohibit it?
Fair enough.
That's the question.
That's the question.
And I think that the legislature clearly had something in mind when it gave us the responsibility or the power to establish parameters for the election. And I think that you've asked the right question. Does it impede our work? Our work is to protect the public interest broadly in the implementation of this gaming legislation and to allow elections to go forward with some kind of a potentially unqualified candidate is to create the possibility, at least, of an election process that is both illusory and a huge waste of public time, money, and energy. And it seems to me, therefore, that insofar as the requirement that no election take place until the qualification has been established it is something that is squarely in our wheelhouse. Again, the relationship to the timing of the signing of the agreement, what the agreement contains, that's a different question for me, at least.
Yeah.
But insofar as the timing vis-a-vis the qualification process, I think it's right on.
Well,
I
let's,
think we should do it.
yeah, let's, let's, if you will, call the question on the referendum issue. If someone would move to answer the question in the affirmative with respect to the referendum, and then let's talk briefly about the host community agreement, because I think they are separable.
So I'll move that the commission establish a policy. Now, I also think it's really important, as this is not a 200-page motion.
Like the last time.
Yeah, like the last time. This is, let me just precede that by saying that what we're reminding ourselves and everybody else, what we're doing today, is establishing a policy that is then going to be embodied in regulations. And during the process of publishing the regulations, as part of that process, the public, everybody who's interested, is going to have an opportunity to comment on the content of the regulation. So although we're creating a policy to help us and the public and the applicants know where we're going, it's not final until we have the regulations. So I think that's an important caveat. But with that caveat.
Could I just
yeah.
say, would it be accurate to say then that these decisions that we're making during these series of questions are advisory, and that they will, until such time as they are put into regs and then approved? Is that language accurate?
Well, it's advisory in a, yes.
Okay.
Gives us direction as to how to
Right,
write the
and
regulations.
it gives our best judgment as of the moment to applicants to
Right.
say, this is where we're pretty
Right.
sure we're gonna come
Right.
down.
Right.
But there is a prescribed process yet to come where people have an opportunity to comment and where we could conceivably change our minds. Okay. All right, excuse me.
And the process is so we can have a consensus as to how we craft a regulation, and also because the regulation crafting process is going to take some time to give people, communities, developers, others who are interested, some guidance in the planning process that's going on right now. So those are the two.
Right.
Anyway,
Right. Okay.
with that in mind, I would move that the commission adopt as a policy that a vote on a host community agreement pursuant to General Laws 23K, Section 1513, may not take place before the commission has made a decision on the qualifications of the applicant.
Second the motion.
Any further discussion? All in favor, say aye.
Aye.
Aye. Opposed, nay. Okay, the motion passes. Now, let's think about the issue of, do we want to extend that same policy to the host community agreement?
The execution. of
To,
the host
to, by,
community.
and by execution, we mean the final signing, I'm not sure what the right legal language is, but the final signing and therefore announcement of the final signing of a completed, done agreement, whatever the proper language is for that. So, what do we think? I mean, my thought is that again, if I were a community leader, I would want to be waiting to hear what's happening, see if there's anything significant that comes out of the woodwork in the background checks. That's what the whole point of the background checks are about. I'd get as far down the road as I could if I was pretty sure the people were going to come out okay. But I wouldn't want to announce to my constituents that I had executed an agreement, final agreement, not knowing for sure that my contracting party, my agreeing party, was going to pass financial and ethical muster. I mean, to me, that's pretty straightforward, but is that, is that an issue that we should impose our judgments on? Does a breaching of that judgment impede our work?
From my standpoint, it doesn't, because inevitably, the host community, through the process of public meetings and the like that are going on right now, is going to begin to hint at what the agreement is going to look like. And if it has a package essentially wrapped up and ready to go, and wants to take the risk of doing that, it gives both the opponents and the proponents even more time than the statute requires to marshal their forces and begin to have a thorough public discussion. And to require, and perhaps, we're looking for ways to shorten the time, and perhaps, depending on the level of confidence that they have that host community vote shortly after the qualification decision is made, rather than signing the agreement after the host community decision is made and then having to wait 60 days before they can have an election.
I
So
didn't follow that. Say, how would that?
So suppose, let's put it in concrete terms. Suppose you were pretty confident that you were going to pass, and suppose you signed an agreement with some kind of an escape clause, which I think any of these would have, but until it's actually done, that if something unexpected happens, we can revise it. And suppose you had an idea as to when the commission's self-imposed deadline for making these qualification determinations was made. You could sign the agreement 60 days before that, make the request, the decision comes, and you could have an election in 2 weeks or 3 weeks, because you would have been going through the process that you're coming
But
down.
if it got delayed, you'd have to then you'd have to start,
postpone.
you'd run the risk of.
Well, that's
yeah.
right, you have
Okay.
to run the risk. And our requirement, and everybody's aware of that requirement, so that the opponents can say, wait a minute, this is too early to be talking about this, because we don't know who's qualified. I mean, it it gives everybody an opportunity to discuss the issues they want to discuss, but it gives the cities and towns maximum flexibility to schedule the election within the constraint that it has to happen after the qualification process is finished. So I would favor giving them that flexibility.
Anybody else?
Well, for all the reasons stated, Mike Pollock's, your others discussed here, I am of the mind that the execution of the agreement should wait until the suitability determination. There could be any number of drafts, a draft circulated for the public to inform. There could be any number of requests for referendum in anticipation to a suitability determination, even if it hasn't happened, and that may be communities and applicants' prerogative. But I would be in favor of having the same type of restriction relative to the execution of a host community agreement. Not until there's been a determination of suitability by the Bureau. And there can be any number of things.
If we don't have that, Commissioner McHugh, if we adopt your approach,
Right.
does it give the community and the applicant, does it give the leadership of the community and the applicant who are in favor of making this happen a sort of a railroading, do they have, does it give them the tools to try to rush this through? Does it give some kind of an advantage to the proponents?
I don't see how it would. It strikes me
If
that.
anything, it goes the other way in a way.
Yeah, I would see it going the other way. It gives everybody a time to discuss this, and, starting tomorrow if they want to. I mean, they sign a host community agreement tomorrow, then which they're not gonna do, but they have from now until whenever we finish to both sides, to investigate, to think about, to talk about, to go to other jurisdictions and look at. The earlier that is joined, the better, it seems to me. And so long as everybody understands that this crucial step is not going to come until after the suitability determination's been made. So it seems to me that, period.
Yeah.
I'd like to hear from Mr. Carroll and Mr. Gushin about the interactive nature of the investigative process and how clear we can make it that we are coming to a conclusion of that investigation.
Well, it is an interactive process. There will be steps taken locally in the Commonwealth of Massachusetts, but there'll also be a broader perspective. And as we've suggested, the Bureau, the IEB will be part of that process. The state police will be, part of that process. There'll be biweekly reports. So I think the most important point that I want to make is there should be no surprises during the course of the investigation. The IEB will be intimately and intricately involved in all aspects of it. So it's pretty clear as the investigation proceeds what the issues are and how they weigh on the statutory parameters for integrity and how the investigation is proceeding.
Excuse me, Brandon,
So
excuse me
there's-
one second. Anybody else want coffee? I'm just asking Brandon to make a coffee run. Thank you. Anybody else? Sorry, excuse me.
So there's no surprises, is what I'm saying.
Correct,
But that is kept, that's not something that is released during the course of an investigation, but the key law enforcement and regulatory enforcement constituencies will be aware of what's happening. The host community may not necessarily be aware of that.
Maybe not the details of the investigation, certainly I understand that, and that's appropriate, but as far as the timing, as Commissioner McHugh has proposed, is there a way to have some interaction that, look, we're coming close to the conclusion so that that may trigger next steps for the
Yeah.
community in order to save some time in the process?
Yeah, I believe there are ways. It's our intention from the outset to have a very close working relationship and continue the flow of information, as Fred has indicated. This isn't a situation where all of the information is accumulated and then it's later on presented as a package. We've spent a good deal of time discussing the qualifiers and rounding out the scope of the identification of the parties that we believe have to be subject to the full-blown backgrounds. And if there are any exceptions, statutorily allowed exceptions, that there's clear justifications for those exceptions. So we believe that having the investigative plan at least taking shape right now, that we'll be able to move very quickly to implement that, and at the same time, keep the information flow coming directly to you as the acting head of the IEB, and you in turn, obviously, to the commission. If there are problems that are identified that we see, and we expect to identify those early, they would be made known to you, and then, further action that would might impact on the overall process could be implemented.
I think the IEB has some broad discretion, as does the commission, as these things proceed. And just in our, prior experiences, there are always uncertain things or things that you least expect that pop up during these investigations, both, it could be in Massachusetts or it could be elsewhere. And again, you'll be aware of those things individually and collectively.
But there could be a way of possibly communicating to a host community without obviously revealing details, but just that the investigation was proceeding, and we anticipate, so that if in fact they wanted to try to cut some time from that 60-day period, there would be a possibility of doing that.
Yeah, I think that's clear, and I think when, again, the 6 months is essentially a maximum time. If, as we've said many times, if that can be expedited, we collectively, as the investigators, will make every effort to do so. But there is a period of time once the report is filed, and then the commission will have the deliberative period to look at it and hold a hearing. But if there are theoretically no issues and the company is absolutely clean, I personally, don't see any reason why that process could not be expedited at that point in time, recognizing, that the commission may look at a report differently than we do. Now, I always want to preserve your ability to question and add conditions and look at things independently.
The one, and I think I get where you're going, and I think we clearly will be trying. I mean, we hear everybody's concern. We will do everything we possibly can, and if we can figure out a way to give an informal word that speeds up the process, we will clearly do that. The one thing that concerns me a little bit is that the tone of the conversation, for understandable reasons, is creating the background check as either a sort of SOP, nothing's going to come out of it, just get it out of the way as soon as possible, or a pain in the neck that shouldn't be had, this thing, it's unnecessary, it's really slowing everything down. Neither of those is right, and obviously you as an investigator appreciate that, but, these are for real reasons. Things are going to come up. Our friends out there, communities and applicants, think they know their teams and think they know everything about their teams. Guess what? They don't. And we've all gone through that. I've nominated for people to serve with me in public positions, and their background checks blew me away, and they couldn't serve. And we've all gone through that. So this is not just, a pain bureaucratic process that's slowing things down. This is really substantive. And any governing body that treated it as just a pain and tried to figure out how to shortcut the process and executed an agreement with a party that they did not know had been found suitable, in my view, would be making a serious mistake. But I think I do come down thinking that it's their mistake to make if they want to.
I would just like to add, if I could, one other thing. And I think getting to Commissioner Cameron's idea, the applicants themselves will be acutely aware of any areas of problem. because the investigators will be
You'll be talking
taking
to them.
additional
Right.
steps.
Good point.
They'll be asked to provide additional information. They'll be asked to occasionally, if it's appropriate, a deposition. So, and they in turn will be in touch with their host community. So they're going to know if there's delays, and, they're not going to go to the town and say, oh, they're taking too long, when they know there's an issue that has to be resolved. So I think in a way that will, assist in the information exchange without anything, being done prematurely.
Thank you, that answers my
Yeah.
question.
That's helpful. Okay, Ombudsman Ziemba, do you want to weigh in on this? Do you have anything to add that hasn't, you don't have to, but if you've got anything else you want to say?
The only thought that I have on this matter is that the commission will be reviewing a lot of other policy questions over the next couple of days that are impacted by the timing of this question. For example, it will be considering whether or not there should be minimum required criteria for those host community agreements. And to the extent that we're really talking about a matter of timing, and it's the timing of the first phase of the applications in that review, the same timing issues are implicated by some of these other questions. For example, if the commission did determine that it wanted to move forward with minimum required content of a host community agreement, and that had to be done through regulations, there is almost no way that we could get those regulations out and on the books prior to, very shortly around the timing of the first phase of the application. So to the degree that the commission hasn't discussed some of those other issues, it may want to table a final vote on this until after some of those questions are resolved, questions regarding permitting, et cetera. They are all baked into almost the same answer. So we have a couple days of deliberations. You may want to consider looking at it in the totality before you have a final vote on that.
Doesn't that cut the other way? I mean, if we say we do not want, we will not make the requirement, that we will not prohibit an HCA execution, how does that impinge on any of the other discussions?
So, for example, if you determine now that you don't want to wait until after phase one for the HCA, and that you want to allow municipalities, through the very good arguments we've heard, to move forward right away on that determination, on that agreement, then some of the other questions that we would consider, such as whether or not we promulgate minimum required content, basically go by the wayside, because there would not be the ability to promulgate those regulations.
Oh, I see.
Yeah, I mean, you could separate it out, but I think there's probably a lot stronger of an argument that you should wait for the first phase to be completed, rather than you should wait for this regulatory process to unfold. So in many ways, the decision on this matter may impact the decisions on some of those other matters. And I'm just saying this in the abstract, given some of the comments of the commissioners on this matter, the second question may reach an inevitable conclusion, but you may preclude that conversation.
I mean, I think, that's an interesting point, I hadn't thought of that. I think, just because we're in it, I think my preference would be to go ahead and make a decision, realizing it's going to be contingent, that when we get to these others, it may cause us to revisit, but I'm open either way.
I think it's an important point, but I also think that if, say, we were to decide that certain permitting considerations had to be in the host community agreement, that the fact that we tie the execution of the host community agreement to the completion of the phase one qualification examination would be to use that as a proxy, that date as a proxy for something else, and it's better to deal with the something else head-on. And the fact that you couldn't realistically sign the host community agreement until you had the licensing piece done would itself determine when the host community agreement was ripe for signing. So, I mean,
They could be viewed
as a
independently. I guess I'm making a value judgment.
I
that
understand.
This is really
Right.
the critical question.
Right.
Okay. So, any further thoughts on, I mean, do you want to postpone this until we talk about the other issues? Or do we want to make a decision now?
Insofar as I'm concerned, maybe we need a vote on that, I hope not. But I think this is a standalone piece, and I'd just as soon now, recognizing that, again, this is tentative. This is our best judgment at the moment. It could change by week's end, but
Yeah, I
But
think we have
this
a
is
busy
good.
week, so I would move to
Yeah,
get
okay.
going.
yeah.
All right, well, does someone want to frame the question on the second piece of this? Mr. McHugh, you did the first one.
Surely. I would move that the commission adopt as a policy that the host community and the prospective, and the applicant, prospective applicant, need not wait until the completion of the RFA1 process before signing a host community agreement, if they choose to do so.
Second?
Second that motion?
Any further discussion? I just, I think I'm going to vote in favor. I just think it would be incredibly dumb to do, but I'm reluctantly, I think I'll vote in favor, Any other comments? Okay, all in favor of, in effect, not precluding the signing of the HCA, say aye.
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 Nay,
Oh, nay.
nay.
Nay, okay, say nay, okay.
Yes.
Commissioner Stebbins, which one?
Aye.
Aye, so four, and Commissioner Zuniga is nay. The motion passes. Okay.
Take a break, Mr. Chairman.
Break?
Can we take a break?
Yeah, and we'll have a real quick break. We'll be back in 5 minutes.